I practice real estate at Clifton Hoff Mayer Attorneys. I'm actually an old student of Stellenbosch University, where I studied business and then law, and then I even completed my doctorate in property law at the South African Research Chair in Property Law here at Stellenbosch. So I'm very much at home. So what will be covered? Firstly, basic property law principles. Then just some information on FICA. I don't think this is anything new. You know this. It's just purely a refresher. Touching on some consumer protection matters as a consolation prize for those who wanted to hear on consumer protection. And then just some aspects of the Protection of Personal Information Act. So as real estate agents, you deal with the concept of immovable property. I think in order to fully comprehend the subject matter, one needs to have an understanding of the basic common law principles in respect of property, and then also some of the statutory requirements. South Africa has has a very old legal system. As you know, we have a Roman Dutch legal system, and so many of our property law principles come from the Roman law and then with the subsequent influences of the Netherlands, and specifically the law of Holland. Our legal system is, for example, older than the current legal system in the Netherlands because their law was codified at a later date. Okay, so let's look at these archaic or old principles. So the concept of immovable property can be broken down in what we call real rights and limited real rights. One also needs to have an understanding of what movable property is in order to differentiate between what is immovable and what exceeds to the land, and what are those assets that can be easily moved from one place or another. It may seem like an obvious distinction, but there's so many court cases on exactly this topic. Is something immovable and is something movable? All right, so the common law says that immovable property is the land and anything that attaches to it, whereas movable property is something that can be easily moved from one place to another, that does not lose its separate identity as a thing, and then if it's removed from the immovable, that it doesn't cause significant damage to the immovable. To give you an example where this becomes an issue is in the case of industrial accession. Often we have clients that come to our firm and say that we want to put up a plant on property that we do not own or on land that we do not own. And what they typically want us to say to them is that once they put up a plant, an industrial plant on that property, is whether they're going to retain ownership of that asset or whether they're going to lose ownership of that asset to the owner of the immovable. Now, usually that's a fight between the lawyers and the engineers because the engineers want us to tell them before they put up the asset whether they're going to lose ownership, whereas our response is always, we have to go and investigate the asset, we have to look at how the asset has been fixed to the land before we can provide you with an opinion. So the Latin term superficie located states that the landowner owns everything that's above the land and anything that is below. There are exceptions with regards to the below. As you know, we have a new mineral rights dispensation, not so new since 2005, where the landowner no longer owns mineral rights. It is now held in custody by the state on behalf of all South Africans. The same applies to water rights. There's a Water Rights Act, and we can no longer have water resources in private ownership. There's also a limit with regards to how far you can own property up into the air. Obviously, at some stage, airplanes are going to crash into what you own, and so they have to put a limit on that. But that's an academic discussion. All right, so then on this principal accession. So if the landowner owns everything that is attached to his land, what is the implication for a real estate agent? So more often than not, we see cases in the courts regarding disputes between private property owners where there was a sale of land on what did they actually acquire, or what did the purchaser actually acquire. I've seen cases where people fight about geysers being removed, about very fancy light fittings being removed. In the cases with regards to industrial buildings, lifts, whether the lift actually acceded to the property, and so forth. And what happens is that once the agreement of sale has been concluded, then the parties start fight and they end in litigation. So to avoid this situation, as an attorney, we're advised that all your agreements of sale has a comprehensive fittings and fixtures list to clearly state what is actually being sold. So last week, I was involved in negotiating an agreement of sale between two parties, and it was a very tiresome exercise because we had to note this pot plant, that mirror, and so forth. In the end, though it seemed like a bit of an overkill, I think it is the best way to proceed. So these clients don't afterwards say, well, I paid nearly 20 million for this house, but you took all the mirrors from the bathroom. Okay, then real rights and limited real rights. Now, the concept of real rights is, I think it's important to have some knowledge of, because when there's a real right in property, and what a real right means is that you either have a right in someone else's property or someone has a right in respect of your property. So depending on the nature of the real right, that real right can in fact affect the value of your property. So for example, if there's a servitude over your farm, that is going to negatively affect the value of your land. Likewise, if you have a servitude over someone else's farm, that's going to enhance the value of your land. Then there's also new real rights that's been created constantly. South Africa does not have numerous classes of real rights, meaning that we don't have a closed system of real rights. And that as our society evolves, new real rights are created constantly. So an example would be the exclusive use areas in sectional title schemes, or the developer's right to extend in terms of Section 25 of the Sectional Titles Act. And then, of course, there are various other statutes that create real rights. So as I said, real rights is something that is a right that you have in respect of someone else's property. Ownership, coincidentally, is also a real right, but it is the most comprehensive real right that you can have in respect of a thing. All the other rights that you can have in respect of a thing are classified as limited real rights. Examples include, as I said, a servitude, then a usufruct over land. As you know, sometimes you want to sell a property or specifically a farm, and then there's a usufruct registered over that farm, meaning that the lady whose husband, for example, passed still has the right to remain in occupation of that property and to use the farm and the fruits thereof for her own benefit. That is a personal real right. And these are all created in the deeds office. Okay. So the difference between a real right and a personal right. A real right is a right that is enforceable against the entire world. So meaning that if there's a servitude registered over farms, the subsequent successors or the successors and title of those farms have to respect and adhere to the registered rights. If that servitude right was not registered in the deeds office, only personal rights came into being, meaning that they are effective inter partes, between the parties themselves, but unless a third party had knowledge of that servitude, he does not have to abide by that contract. So that's ultimately why we register things in the deeds office for the publicity principle, so that it's records that it's made available to the public, and people ought to know that these rights exist. Okay, so that's the first thing. Real rights are enforceable against the entire world. And then, more importantly I think for real estate agents and for property lawyers, is that if a real right is classified as an immovable, then you can register a mortgage bond over that real right. So what does this mean? So firstly, when is a real right classified as an immovable? Is if you have a real right in respect of immovable property, the real right itself will also be considered to be immovable. Therefore, we can register a bond over it. In Johannesburg, Cliff Decker was involved in a big development, and it may ring a bell. It's called Waterfall. It's between Johannesburg and Pretoria. And the story behind that development is that the land is owned by a Muslim family. It was gifted to them by Paul Creer way back when. And they believed that they cannot sell the land because it was in fact a gift from Allah. But they wanted to develop the land for residential purposes. And we had to find a way around that. So the way we found is by registering long-term leases. A township was proclaimed on the property. Irvin was obviously laid out, all the services and so forth put in. But what the people acquire in that estate is a 99-year leasehold. So they don't become the landowners, but they do have a limited real right in that property. So initially the banks were quite wary to finance these acquisitions or these Irvin because they said that you don't own the land. But after a lot of talking to them and convincing and fancy footwork, the banks are now all involved, and they are financing the people's acquisitions, the client's acquisitions in the scheme. What they did to get away around the fact that they don't own the land is by building in they call it an extension. Anytime before the expiry of the 99-year period, the owner of, or the registered lessee can pay 3.5% to renew his leasehold rights, and then it tops up and it can actually operate in perpetuity. So that's an example of where you had a real right and where we registered a mortgage bond over the real right. Of course, you have to look at the nature of the real rights. Some real rights will not necessarily be great security. So it is silly to register a bond over something like a servitude, for example. But depends also on the servitude. Okay, so that is the common law on property or ownership, real rights, and limited real rights. What does the legislation say? Okay, so Section 1 of the Alienation of Land Act states that land includes any unit. So, for example, in a sectional title scheme, any right to claim transfer of land, an undivided share in land, any land to be used for residential purposes, a housing interest in the housing schemes for retired persons, and also a share in a share block scheme. These are all in itself quite interesting legal subjects. So, for example, a share in a share block scheme. This is where you have a company that owns property, usually in the leisure industry, holiday, and then what you acquire is a share in the company which confers on you the right to occupy that property for a certain period of time. Then Section 102 of the Deed Registries Act states that immovable property includes a registered leasehold and a long-term lease. So that would be the waterfall leases. So how does ownership pass from one person to another in respect of land? So the common law has 3 requirements. And these requirements come from Roman times. So first there has to be a contract of sale. A contract, it doesn't have to be a sale, it can be a donation, it can be an exchange agreement, whatever the case may be. But you usually deal with contracts of sale. Then the person's giving transfer and the person's receiving transfer has to have the necessary legal capacity. There are some aspects that may influence the legal capacity, and we'll deal with that later. And then, and this is the most important, the transferor, which would be the seller, must have the intention to give transfer, and the transferee, which is the purchaser, must have the intention to receive transfer. This is called the abstract theory of transfer, but what it basically means is that there has to be a meeting of the minds between the parties. If there is no meeting of the minds, so for example in the case of fraud or omission or misrepresentation, then that transfer will not go through because the real agreement, which is the legal term for this concept, is lacking. And then, of course, to give effect to the publicity principle and also to the delivery principle, we register in the deeds office. If you, for example, acquire a car, then you take delivery of the car by putting the keys in the ignition. Now, that is registration in the deeds office is similar for immovable property. But now, this abstract theory of transfer throws a bit the spanners in the works. Why? Because there can be instances where registration has taken place in the deeds office, but where there was where the real agreement was lacking. So you can draw your document from the deeds office, and you can see that the party was sold from A to B. But this may not necessarily be the case. So the rule is that you have to presume the correctness of the deeds registry until proven otherwise. I can give you an example. Any conveyancer's worst conveyancing matter is a rectification transfer. What happened in this one case that I'm working on, and it's been coming now for nearly 8 months, Mr. and Mrs. Wright. They acquired a sectional title unit in a scheme called Crowthorne Village in Johannesburg. And the estate agent filled in the door number of the unit instead of actually looking on the sectional plan. So what happened was, and this is also the conveyance who at the time who did the transfers negligence, is that the wrong property was transferred into their name. Now, basically, well, on the basis of the abstract theory of transfer, Mr. and Mrs. Wright did not have the intention to buy the unit that was transferred in their name. But now the deeds office records have to be rectified, and it's an absolute nightmare. Mr. and Mrs. Wright has a bond over the incorrect property because the bond was registered over the incorrect property, but they're living in property that's owned by someone else, still owned by the developer. And I've been fighting with Mr. and Mrs. Wright to approach the bank, because what we will have to do is we'll have to cancel the bond and re-register it over the correct property. But obviously, they don't want the bond to be cancelled. They're concerned that maybe they won't get as favorable an interest rate. They don't want to have lost the benefit of paying off so much. And I think these fears can be dealt with by the bank, but I can't get them so far as to approach the bank. And so it's been 8 months now, still going on. I hope we will transfer that property by the end of the year. Because the conveyancer was appointed by the developer at the time when the transfer was done, the developer said that they'll pay all costs involved. Okay, then there are, of course, statutory requirements with regards to passing of ownership of land. Firstly, Section 2 of the Alienation of Land Act states that when it comes to selling immovable property, it has to be contained in a contract of sale. It has to be in a deed of alienation. So that's why you can't have a verbal agreement for the sale of a house, for example. It has to be in writing. Section 16 of the Deeds Registries Act also states that ownership of land must be conveyed from one person to another by way of a deed of transfer. As you all know, other real rights, limited real rights, are transferred from one person to another by way of a notarial deed of cession. So we transfer land, but all other rights we cede. Then there are certain consents that you must be aware of that can affect the validity of your agreements. Some of these consents emanate from your title deed, and some of these consents emanate from legislation. And depending on what the consent requires, it can in fact affect the real agreement, the meeting of the minds principle. So consents in terms of your title deed, by far the most common are preemptive rights. So for example, this property can only be sold once it has been offered to a third party, and that third party has said that he does not want to buy that property. Sometimes property has to be sold, but you have to get the consent of the usufructuary, so she can also give her transfer of her usufructuary rights. In that instance, you will transfer the bare dominium, which is held by the owner of the land, together with the limited real right that is held by the usufructuary. Okay, and then homeowners association conditions. Homeowners association conditions. So typically, a homeowners association will impose a condition that they will not consent to transfer unless they've issued a certificate which states that all levies have been paid. I'm busy drafting agreements for a wildlife estate in Johannesburg, and there is an existing homeowners association in this estate, but then we will also create in respect of individual urban time-sharing schemes based on co-ownership. And so what I will do in the title deeds is I'll create a similar condition in favor of the co-owners, stating that if your levies have not been paid, which will include the levies payable to the homeowners association, the co-owners will not consent to the transfer of your property. So recently, in the Supreme Court of Appeal, this homeowners association condition received some attention, And what the court found is that these rights created in favor of the homeowners association takes precedence over the rights of the bondholder. So the implication is if the client defaults on his loan and the bank wants to foreclose on his property, the homeowners association is under no obligation to proceed with the sale and execution unless its levies have been paid. So what the bank will have to do is pay the outstanding levies, pay the outstanding rates and taxes, because there's a similar case in respect of rates and taxes from the municipality, and then can it only proceed to put that house on auction. Important statutory consents. By far the most common is your consent with regards to the subdivision of agricultural land. So that's in terms of the Subdivision of Agricultural Land Act 70 of 1970. And it states that agricultural land may not be subdivided unless you have the consent of the Minister of Agriculture. The Act goes so far in saying that you may not even enter into an agreement of sale, subject to the condition that the land will be subdivided. At our firm, we've obtained council's opinion on this because it was a very onerous provision, and it's one that we deal with on a regular basis. We're always trying to find a way around it. And the opinion is that such an agreement will be invalid from the outset. There are, of course, also certain limitations with regard to registration of servitudes over agricultural land. There's a very small margin. The servitude can only be a certain size. If it goes over that size or length or meters, then you also need the minister's consent. Now, this has become very relevant in the renewable energy projects. I don't know to what extent you've seen them. They're very popular in the Northern Cape, where you have a renewable energy company who wants to put up, for example, solar panels or a windmill on a farmer's land. In order to do that, he will need to register. He either needs to subdivide the land, because the main issue here is tenure of security. They want to create a system where they will not be kicked off the land at any time. That's mainly a requirement from all the financiers. Or they need to register servitudes over the land. And this provision has caused a lot of trouble, to such an extent that what the law firms now do, they advise that the renewable energy company leases the entire farm, because you can also not register a lease in respect of a portion of agricultural land. Leases the entire farm, and then the farmer has informal rights to continue with his farming activities. So whether that scheme will hold up in court is something we'll still see. There's in any event a new piece of legislation in the pipeline that's going to replace the Agricultural Land Act. Okay, other consents. This is relevant in Johannesburg. I think it will also be relevant in Cape Town, of course, depending on municipality bylaws and also the size of your average properties. But in Johannesburg, we have very large urban in-townships, and so you need the local authorities' consent to subdivide that earth. Again, you need the consent before you can enter into agreement of sale. That agreement will be invalid if you don't have the consent in place first. Then, of course, you need your spouse's consent in terms of the Matrimonial Property Act if persons are married in community of property. So Section 15 of that Act states that a spouse may not, without the written consent of the other spouse, alienate immovable property, burden it with a mortgage, burden it with a servitude, or confer any real right in that property. The Act further states that the spouse may not enter into an agreement of sale or enter into a contract to mortgage or to burden or even to register a servitude over the land falling within the communal estate. However, the general view is that such an agreement can be ratified by the other spouse. So there's a distinction. The danger is not in entering into the agreement, it is in the actual conferring of a real right or the actual sale of the land, which will be invalid. Then, property owned by minors. I don't know whether this is relevant still, maybe it's a bit esoteric. Minors under the age of 7, as you know, have no contractual capacity, which means that their guardians must sign the agreements of sale. If minors are aged between 7 and 18, then they must be assisted by their guardians, though they sign themselves. But Section 80 of the Administration of Estates Act states that if the property of the minor is valued at less than 100,000 rand, then you require the authorization of the Master of the High Court to proceed with that transaction. If the value of the property is more than 100,000 rand, you need the court order from the High Court to proceed with that transaction. Okay, so in addition to your ordinary sale of land, there are other legal schemes that, in respect of immovable property, which you as estate agents will deal with on a regular basis. I'm not going to go through it in detail. You will have a separate session on sectional titles if you haven't had that already. And then I'll just refer to the other schemes. If you require further information, you can take my card and contact me. Okay, so as you know, sectional titles is governed by the Sectional Titles Act. What is a sectional title scheme? So I referred you earlier to the principle of superficie so located. The landowner owns everything above and below the land. And so prior to the coming into operation of this piece of legislation, it was not possible in South Africa to own a flat on the 8th floor of a building, because if you did not own the land, you do not own the building. So sectional titles legislation is a way of getting around that. What it basically does is they take a piece of land, transfer it from the land register to the sectional titles register, and then obviously they open a sectional title scheme. And as you acquire a unit in that scheme, you also acquire an undivided share of the common property. So it is a three-dimensional concept of ownership, which is relatively new, only since the 1970s. But it has fast become very popular. So in Asian countries, it is I think the by far popular way to buy residential property. Also in Australia, New South Wales, where they call it strata titles. And in Johannesburg, you see new buildings being built every month. New buildings on every street. It's actually phenomenal. Okay, so what do you acquire when you acquire a flat? The legal term is you acquire a unit in the scheme. And what is a unit? It is your section together with your undivided share in the common property, and that undivided share is apportioned according to your participation quota. So as you know, the participation quota is determined by calculating the floor area of your section and then looking at the floor area of the entire building, and then it's a simple sum and it comes to a percentage. It's on one of the, if you look at the sectional plan, I think it's on the last page of a sectional plan. Okay, and common property, as I said, that is the land on which the building has been built. The common property is owned by everyone in undivided shares. And it will typically be something like the stairs, the lifts, and so forth. Then, of course, you can get exclusive use areas. Exclusive use areas is a bit of a sticky situation, mainly because they can either be personal rights or they can be limited real rights. And the Act provides for 3 ways in which exclusive use areas can be created. There's a cheaper way and there's a more expensive way, and usually developers will opt for the cheaper way. The cheaper way is by demarcating the exclusive use areas and creating them in terms of the rules of the scheme. So what the parties actually have is personal rights. It is enforceable against themselves or between themselves inter se. It's not very secure. Though one can argue that if the garden is in front of my flat, who else is going to use it? Then you can get exclusive use areas that's created in the deeds office, can be created by the developer or by the body corporate. And what they do is they get your land surveyor who surveys the exclusive use areas, and they're incorporated on your sectional plan, they're registered in the deeds office. And so when you sell your property, then you also cede your real right in your exclusive use area. I recently acquired a flat in Johannesburg, and I went to view many properties. And my first question to the estate agent was, is this exclusive use area a real right in property? And many of them did not understand the distinction. And when I would go back to my office, I would do the search, and I would see that this is only a personal right, so I don't acquire a real right. It's just something to bear in mind. Okay, and then your real right of extension. When a developer opens a scheme, he reserves the right to develop the scheme further in phases. He has to do that when he opens the scheme. So that's called a Section 25 right. This right has to be disclosed if it is in existence. Otherwise, the purchaser has a right, has a cooling off period to pull back from the sale. I think it's a 5-day period. The real right has a time limit on it. So, for example, the developer must develop within 10 years or 25 years. It's not a right that's in perpetuity. It will also, for example, state that he has to use the same materials and so forth as it's used in the first phase of the development. Then other property schemes. I referred you earlier to share block schemes, popular for holiday accommodation. Recently, we consulted with a client who also wanted to do the timeshare development, and what they wanted to do is a share block company in actual fact. What many people don't realize is as soon as you transfer property in a company and you sell shares in that company, you fall under the operation of the Share Block Schemes Act, and that can be quite onerous in terms of regulating. So there are many illegal share blocks in our country. I think very few people are acquainted with this act. So it's worth your while just to read through it. It's quite short. Okay, then timeshare. Timeshare in the Property Timesharing Control Act. Timeshare is not a legal concept by itself. It does not stand on its own. It is a concept that is usually coupled with another legal concept. A share block scheme, for example, as soon as that share confers a right to occupy property for a specified period of time, then it falls under the operation of the Timeshare Act as well. The development that I told you of earlier, that I'm drafting the agreements, and is based on co-ownership. So there's 38 urban that the bank wanted to develop. And what we're going to do is we're going to establish a timeshare scheme in respect of each earth. So each earth is going to be co-owned by multiple owners. And even though they are the landowners, they will also have to abide by the provisions of the Timeshare Act, because their right of ownership confers on them the right to occupy the lodge for example, 4 weeks in a year. Then timeshare can also be based on retirement villages and also the club system. So for example, Sun City, some of those developments in that area is based on clubs. So that was a theoretical understanding of property and immovable property. Let's get to the nitty-gritty, the practicalities, the offer to purchase. So as a conveyancer, what I receive from the estate agent is the offer to purchase. And our offer to purchase is an agreement that has to meet certain common law principles. Again, this is Roman law principles. And in terms of the common law, when it comes to an offer or an agreement of sale, there has to be 3 clauses present. Otherwise, that agreement is invalid from the outset. So we call it the PPP. Property, purchase price, and parties. Now, this seems pretty straightforward, pretty obvious, but this is often where certain mistakes slip in, which can, in fact, affect the validity of the agreement. Okay. So firstly, your property description, it needs to be accurate. As conveyancers, we require a full deeds office description. Now, of course, it is the conveyancer's responsibility to double-check the description, but you don't want a situation where your agreement is invalid before the conveyancing process has started. Often I see street addresses on the offers to purchase. That's not considered to be legally a correct property description. Also, make sure, as I explained with Mr. and Mrs. Wright, make sure that you refer to the correct unit as referred to on the sectional plan, and don't use something like the door number or even the section number. This can be very confusing. Make sure that there's the correct unit on that agreement. Then the purchase price. It must be clear whether this is a VATable or a transfer dutiable transaction. We'll get to the difference between VAT and transfer duty in a moment, but it must also be clear whether that agreement, whether that sale, if it is VATable, is inclusive or exclusive of VAT. Because if you don't specifically state that it is ex-VAT or inclusive of VAT, the law says that we presume that it is then inclusive of VAT. So what you can have is then a seller who says, well, you did not specify, and now I'm 14% short. Party descriptions. Okay, so party descriptions is important. Accuracy is important because mistakes can, in fact, affect the authority to enter into that agreement. So when it comes to a natural person, obviously full name, identity number. When it's a juristic person, full name, registration number. And it's important to verify who buys the property and also if he is, in fact, authorized to enter into that agreement of sale. So, for example, when you have a company and there's a director who's acquiring property on behalf of a company, does that director have the necessary resolution in place, authorizing him to enter into this agreement on behalf of the company? Another important resolution with regards to companies is your 112 resolution. If the asset that's being sold is the sole asset of that company, then you require a Section 112 resolution by the shareholders of that company. Then, in the case of deceased estates or insolvent estates or even persons who's been placed under curatorship, those executors need letters of authority from the master. They do not have authority to act without those letters of authority. So don't be in a situation where an executive, for example, enters into an agreement and you haven't asked for those letters of authority, because that agreement will be invalid from the outset. Then also just note the risk, and I'm sure you all know this. If a person signs an agreement on behalf of a nominee, as you are aware, that person can, in fact, have the consequence of paying double transfer duty in terms of Section 16 of the Transfer Duty Act. Section 16 requires that they disclose who the nominee is, the nominee's identity, on the day of the conclusion of the sale. So once that agreement has been signed, 24 hours starts ticking, and you have to disclose who the nominee is within that 24 hours. Otherwise, you will have a situation where the person who entered into the agreement, we're going to have to transfer to him. He's going to pay transfer duty, and your nominee is going to pay transfer duty. Because the Deeds Registries Act tells the conveyancer that we have to follow the relative causes of the transaction. So I will then first have to transfer from A to B and then B to C. And obviously that is very expensive. Okay, types of authority that is required. We've gone through most of this. I just want to bring some of them to your attention. Okay, so we know the executive of a deceased estate or insolvent estate, you need your letters of authority. Then in the case of property owned by a minor, you need, depending on the value of the property, either the consent of the master or the consent of the High Court. Property owned by a person under curatorship, again, letters of authority. Then you have a company or a company to be formed. Can a person enter into an agreement on behalf of a company to be formed? Yes, you can. But the rule states that that company has to ratify that agreement within 3 months of its formation. However, if they don't expressly ratify that agreement, then it's presumed that they in fact did. Okay, so that's a safe one. What about a trust? No. Why? Because the trustee needs his letters of authority. So if the trust is not yet formed, the master is not going to issue the letters of authority, which means that the trustee is acting on behalf of no one but himself. So if a trustee enters into an agreement on behalf of a trust to be formed, that agreement is void in ab initio. It's invalid from the start. It cannot even be remedied. Okay, other important terms of your agreement of sale. Condition precedent, as we say in in the law firm, but you would say a suspensive condition. The most common ones are subject to the purchaser selling his house, or subject to the purchaser obtaining bond approval within so many days of the signature date. It is standard to require bond approval within 30 days of the signature date, and then I've seen some agreements that also provides for an additional period of 30 days if he has failed. Depends on how your agreement reads. Delivery of the guarantees, that's an important clause. Okay, here I would like to emphasize that make sure the delivery of the guarantee time period is practical. So once your bond has been approved, usually agreements state that it has to be delivered, guarantees have to be delivered within 2 weeks from bond approval. But my experience is that that never really happens. I can give you the example of the holiday home that my family just acquired. We got an Investec bond, and Investec has a lot of additional requirements that has to be met before they will give the bond approval. So we were late on the bond approval, and then we had to get the guarantees. Additional requirements again. We were so late with those guarantees, it caused a lot of stress in my life. So just be practical and be reasonable. A more realistic time period is 3 to 4 weeks from bond approval. Okay, and then the deposit that has to be paid by the purchaser. In terms of the Attorneys Act, it states that it may be invested into an interest-bearing account. Previously, we had questions from estate agents who said that their conveyancers refuses to invest the deposit. I referred to the Act, and my view is that if the purchaser has requested the deposit to be invested, then it would be unethical for the attorney to refuse. So make sure that you submit with your agreement of sale to the conveyancer and express instruction to invest that money into an interest-bearing account. Foot stewards clauses. So the CPA has affected or has implications for the foot stewards clause in certain agreements, but in your ordinary arm's length transaction between a purchaser and a seller, when they're not selling homes as part of their business, just selling their residential property, you can have a foot stewards clause or a foot stewards provision, but bearing in mind that it will not protect the seller in the case of a latent defect, which the purchaser can show the seller was aware of and fraudulently or intentionally failed to disclose. So referring back to that agreement that I drafted and all the fixtures and fittings that I had to specify, in that agreement, the seller was very pedantic about disclosing everything. I received emails from him every second day. Then I have to put into the agreement that the tap is leaking. Then I have to put into it that there's a leak in the roof. I don't know what else. In the end, I just added them as annexures, and I made sure that the purchaser was aware of them. But again, err on the side of caution, disclose everything, and sleep well at night. Then agent's commission, again, specify, does it include or exclude VAT? Because if you don't specify, we're going to assume that it is inclusive of VAT. And then, just as a kind request from the legal folk, when there's more than one agent on the transaction, please submit both VAT registration numbers. That was an instruction from my secretaries. What about undertakings? For the holiday home, the estate agent again asked for an undertaking for the agent's commission. And our firm policy is that we give undertakings, but they will always be conditional. They will be conditional on the fact that we have control over the funds, and they will be conditional on the fact that there will be sufficient funds to cover the agent's commission. Because ultimately, we have a contract with the purchaser, a legal relationship with the purchaser and the seller. We receive the funds on their behalf. We don't have a legal relationship with the estate agent. And so we receive our instruction and our mandate from the parties to the sale. And that's why we cannot give an unconditional guarantee. However, once those conditions have been met, then the guarantee becomes unconditional, and then there's no reason for the conveyancer to refuse to pay out the commission. And then lastly, when it comes to filling out your offer to a purchase, please be specific. And lawyers, make this mistake, I make this mistake. I made the mistake 2 weeks ago, where I meant that in a breach clause, I said that you have to give 30 business days notice in order to cancel the agreement. 30 business days is a long time, it's 2 months, as opposed to 30 days. And so that's a mistake that I made, and the agreement can only be cancelled today. I'll have to send that letter. Also, difference between month, calendar month, and so forth. Then certificates. Any sale has certificates that has to be exchanged between the parties. By far the most common, electrical certificate of compliance. The legislation reads that we may not give, property may not be transferred from one person to another without that party's being in possession of an electrical certificate that is valid that is not older than 2 years. So this becomes an issue, especially with the big buildings, when people buy and sell big buildings in Johannesburg, because getting your electrical compliance certificate up to date is quite expensive, especially if you're in the market of inner city buildings. And so even though the legislation clearly states that you need that certificate in place, the parties often negotiate amongst themselves. So it would say that the purchaser will get the certificate or the seller will get the certificate, but only at that date, whatever the case may be. The reason we can get away with this arrangement is because the certificate doesn't have to be lodged at the deeds office, and there's no one checking up on us. That being said, if I was the purchaser of a property, I would insist that that certificate be there. I will not take the financial responsibility of getting the certificate by myself. Okay, then in big buildings again, lifts or escalator certificates. Gas certificates. I don't know to what extent there's gas in Stellenbosch and Cape Town, but Johannesburg, we have very old gas connections. So the gas certificate is requested quite often. In Johannesburg, the electrical fence certificate is also requested quite often. In Cape Town, plumbing certificates. That's not something that's required in other areas of the country, but in the Western Cape, yes. Then in coastal areas, entomologist certificates for those borer beetles. Then in Johannesburg, I also got, and I didn't know this, but a borehole certificate in agricultural farms or agricultural properties. Something to look out for. It's not something that I've ever come across, but I'll have to check the legislation. And then invasive species certificate. I've heard a lot of complaints on this, I think because it's very difficult to enforce. What I can tell you is that there are now consultants who has schooled themselves in knowing what is invasive and what is not. I have some cards here if it's something you would like to know. And the consultant will then provide that certificate. VAT versus transfer duty. So when is a transaction VATable? When is it subject to transfer duty? So the rule is that if the seller is a VAT vendor and he is making taxable supplies in the furtherance of his business, that transaction will be subject to VAT. So an example would be a developer who develops 60 units and then on-sells it to third-party purchasers. Those third-party purchasers think that they actually win because they don't pay transfer duty. Now, yes, technically the developer has a responsibility to pay VAT, but we all know that the developer builds in that VAT into the purchase price. So the onus is on the developer to pay 14% because he is making taxable supplies in furtherance of his business enterprise. Then, what if both your seller and your purchaser is registered as VAT vendors? So in that instance, you have to determine whether your transaction is subject to the exemption provision in Section 11(1)(e) of the VAT Act. I don't think that is something that you will deal with often in Johannesburg when it comes again to the sale of buildings from one person to another or one company to another. This is where it is usually applicable. But just shortly to explain how the process works, is if the seller is selling what we call a going concern. So he is selling his building, 10 stories, and all the leases that goes with that building. So he's ceding all the lease agreements, he's ceding the management contract, and anything else that makes his business viable to the purchaser. The seller and the purchaser are both registered as VAT vendors. Then that transaction will qualify to be zero rated. So then there is no VAT payable on that transaction. It is very difficult to prove that is in fact a zero-rated transaction, and because what needs to be transferred to the purchaser is everything that he needs to run that business, and it needs to be a going concern capable of separate operation at the moment when it's transferred. So you cannot sell a building and say, well, I have 60 potential tenants. Those tenants need to be in place, they need to live and they need to pay a rent. It becomes an issue with the bigger shopping centers, where the shopping centers are co-owned by more than one owner, and one owner wants to sell his share in the shopping center, and the argument would be is whether a share is sufficient to constitute a going concern which is capable of separate operation. The general view of SARS is that a share in something is not capable of separate operation, and therefore they cannot qualify for your VAT exemption. Then any other transactions is subject to transfer duty, and that's of course for the purchaser's account. As you're aware, and you can go and refer to the new schedules, SARS brought out new schedules that makes it more tax heavy for the wealthier end of the scale and less tax heavy for the lower end of the scale. So I calculated the transfer duty on my sister's flat, which she wants to sell, for 870,000 Rand. Transfer duty is only 4,000 Rand on that transaction. So that's the implications of the new scale. You can go and look at it on the SARS website. And then just from a practical implication, it's beneficial to have your client's income tax numbers because the conveyancer is going to ask for them, or their VAT registration numbers. These numbers have to be submitted to SARS so we can get our transfer duty receipt. Yes. Then capital gains tax. I must admit this is not something that I'm very comfortable with because we have a tax department in our firm, and so I've never taken the time to do the calculation. But as you know, capital gains tax is payable on the difference between the amount that the property is sold for and the base cost of that property. So prior to 1 October 2001, capital gains tax came into operation on that date, and so you had to calculate your base cost at that date for purposes of doing your capital gains tax sum. Then for any properties that was acquired after that date, you calculate your base cost by looking at all the costs involved in acquiring that property. So this will include obviously the purchase price, then your transfer duty costs, even your state agent commission, and also includes renovations to the property, but not routine maintenance activities. So you take all these costs into account, you calculate the base cost, and then you have the responsibility to calculate the capital gain. So there are certain exclusions for capital gains tax in your annual income. So there's an annual exclusion of 30,000 Rand, and then a further exclusion of 300,000 Rand in the year of the death of the seller, and then 2 million exclusion on the profit made of a seller's primary residence. And the rate of inclusion is that if it's a natural person or a special trust, then 33.33% of the capital gain must be included in your taxable income. If it's a company or a closed corporation or a trust, 66.66%. Then moving on to deeds office processes. It feels to me in my practice or in our practice that it is a fight or it's a bit of a difficult relationship between the conveyancer and the estate agent. I think because the estate agent feels that the process should go quicker. So let's just see what the process looks like, and perhaps maybe we'll have more appreciation for both our concerns. In any transfer process, there is at least 2, sometimes 3 attorneys involved. So you have your transfer attorney. Then if the purchaser is acquiring finance from a bank, we have a bond attorney. And if there's an existing bond over the property, we have a cancellation attorney. The transferring attorney is the attorney that's responsible for bringing everything together and has by far the largest responsibility. So he liaises with your bond and your cancellation attorneys and is responsible for requesting cancellation figures from the bank in respect of the cancellation of the existing bond. So you all know that there's a 90-day notice period that's been built in. We have to give the bank notice of the client's intention to cancel that bond, and if there's an early termination of that bond, then there's termination penalties payable. So we've had a lot of debate over the course of these seminars with the estate agents on when do you have to give this notice and whose responsibility is it? And we've reached the conclusion that it is the seller's responsibility. As soon as he becomes aware of the fact that, well, as soon as he decides that he's going to dispose of his property, even if the agreement of sale is not yet in place, advise him to give the bank notice so that 90-day period can start running. The conveyancer will, of course, also request cancellation figures, but at that stage, transfer may take less than 90 days. It doesn't happen often, but it can. And then the cancellation, the seller may have to pay penalties. So as soon as that agreement is signed, tell him to let the bank know. The notice period of 90 days will start on the receipt of the 90 days. So it's also advisable for the seller to just keep record of when he informed the bank, so there's no dispute later on. Then rates clearance figures. As transferring attorneys, we have to ask for rates clearance from the municipalities. And maybe in the Western Cape you don't have such difficulty as we have up in the north, but depending on your municipality and you know your customers, getting those cancellation figures can actually be a bit of a nightmare. So if I get an instruction to transfer property and it falls under the Ekurhuleni municipality, I know that the transfer is going to take slightly longer as opposed to, say, a transfer in city of Johannesburg. Just bear in mind that this can cause a delay in your transfer. And then also, earlier we referred to the real right that's created in favor of the homeowners association when it comes to issuing the certificate for paying of the levies. Similar right is created in favor of the municipality, actually quite concerning. In the SCA decision recently, the court said that the municipalities have a lien, which is also a form of a limited real right, in respect of outstanding rates and taxes. So Section 118(1) of the Municipal Systems Act requires rates and taxes to be paid for the 2 years preceding the date of transfer. That's what they issue your certificate for, before transfer may continue. But there is often, and I think this is perhaps more an issue again up in the north, especially with inner city buildings, historic rates and taxes and historic rates and taxes debt. And so the implication of this decision is that the municipality can hold you liable for the historic debt. What makes it practical or practically problematic is that it seems that this limited real right follows successors in title. So the implication of this decision, and we're waiting for it to be challenged by the constitutional, or to be challenged in the Constitutional Court, is that the municipality can claim historical rates and taxes perhaps from a new purchaser of that property. Now surely that's not a viable solution or viable option, and so we're hoping for this matter to be resolved soon. Okay, then we have to get the transfer duty receipt from SARS. Now, this is usually straightforward, but I have come across instances, and especially when it comes to agricultural land, where there's mining activities and where the parties sell property for a nominal value because they don't want the land, they want the mine. And so when I submit the purchase price to SARS or the value of the land, SARS comes back and say, well, hang on, how can this be the value of the land? And then I get directed to get 2 independent valuations for that property. And of course, this can take a long time because you have to get 2 independent valuators to go out on the farm and to determine the actual value of the farm. So in a transaction we recently did, we were under the whip to get the transfer through because there were certain conditions that had to be fulfilled in order for the agreement not to fall over. It was a commercial transaction. Transferring the property was just one aspect of the agreement. And I couldn't make the deadline because SARS said I had to go and get these 2 valuations for the land. And so the implication is that the agreement fell over. The parties are now litigating and fighting about that aspect and also other aspects, and we'll see what happens. Okay, then homeowners association and body corporate certificates, we've gone through that. Okay, then the fees for the transfer is for the purchaser's account. But it is the seller's prerogative to appoint the conveyancing attorney. Now, I personally think that's a bit of an unfair situation. Durban, coincidentally, or in KwaZulu-Natal, it is the purchaser's prerogative to appoint the conveyancing attorney. Then, bond attorney is responsible for ensuring the new bond to be registered, and also the fees are for the purchaser. And then the conciliation attorney, fees are for the seller. Okay, then in the news, you've heard about this regulation of land holding bill. We'll see how that bill is going to affect us in future. But what it does envisage is limiting foreign nationals' ownership of land. It initially appeared to be all land, but now they've since changed the wording of the legislation, and it reads now agricultural land. And it appears that foreign nationals will in future only be able to enter into something like a long-term lease agreement in respect of agricultural land. Though this would be new in South Africa, I've reviewed many lease agreements from all over Africa. It happens, a foreign national does not get land in other countries as easily as they do here. Then the bill also proposes to impose a restriction on the amount of agricultural land that people can hold. They envisage a 12,000 hectare limitation. I think possibly in the Western Cape that is viable, but if you have the larger game farms up north, maybe that is not a viable solution or a viable option. The legislation is tabled in Parliament this month. We'll see. Okay, you're going to have a rental housing lecture, but let us just go through the hier gaat voorkoop principle. So the hier gaat voorkoop principle states that you sell your land, but subject to the existing lease agreement that's in place. So your purchaser cannot kick the lessee out. Okay, that's simplified version. The hier gaat voorkoop principle relates to lease agreements that are considered to be short-term leases, so that's leases that's less than 10 years. If the lessee wants real protection, meaning protection which is enforceable against third parties, then he needs to have that lease registered in the deeds office after the period of 10 years. So if your property is sold subject to a long-term lease agreement, which is not registered in the deeds office, the purchaser will have the right to kick out the lessee unless it can be shown that he was aware of the lessee when he signed the agreement of sale. Again, a benefit of having your lease registered in the deeds office is once you've registered it in the deeds office, you create real rights, which of course can be encumbered by a mortgage bond. Then, as in the case of agreements of sale, just bear in mind that there are certain statutory restrictions to the entering into these agreements. Obvious example being Subdivision of Agricultural Land Act. You may not enter into a long-term lease agreement in respect of a portion of Agricultural Land Act. You either have to lease the entire farm or not at all. And then, of course, your structure of your lease agreement depends on the nature of the property being leased. Some of you may deal with residential lease agreements, some of you will be in the commercial property sector, so the terms will be tailored accordingly. Then, as in your agreements of sale, there are certain essential terms that has to be in a lease agreement. So, there needs to be an undertaking by the lessor to give and use the enjoyment of the property to the lessee. The lessee needs to agree to use and enjoy the property, and that use is temporary, and then there must be an agreement to pay a sum for that use and enjoyment. Those three provisions has to be in the contract of lease, otherwise the lease is invalid. Okay, FICA, we all know how FICA works, just as a reminder. Estate agents as well as attorneys are considered to be accountable institutions as defined in the Act, and therefore we are all liable or responsible to ensure that we are FICA compliant. Okay, so when does your FICA responsibilities arise? First of all, establishing a new business relationship with the client, and during the life cycle of that business relationship. So the implication is the moment you enter into some form of mandate agreement with a new client, you have a responsibility to obtain the FICA documents from that client. Your responsibility is not deferred at a later stage until you have an agreement of sale. That is not right. It is from the inception, from the moment that you have that relationship, your FICA responsibilities arise. What are these FICA responsibilities? Okay, so first of all, collect your FICA documents. And then also, accountable institutions has to keep these documents on their premises for a period of 5 years. Then you also have a responsibility in terms of FICA to report suspicious transactions. What is a suspicious transaction? I mean, I don't think it's something that you can really define. But, for example, if the proceeds is from an unlawful activity, so if a person is buying his house and you know that he got the money to buy that house from selling drugs or something, then that is a suspicious transaction. It has to be reported. And any cash transactions in excess of 25,000 Rand must be reported to the Financial Intelligence Center. The obligations is know your client. As we said, when you establish that business relationship, you have to verify his identity and you have to maintain your records. Then report suspicious or unusual transactions, and then also you have to have an internal compliance officer. So if you have a one-man estate agency business, then you are your internal compliance officer. If you have a larger business, you have to at least have someone who's responsible or charged with the responsibility of maintaining your FICA records. We have a person at our firm who's responsible for maintaining our FICA records, and I have fights with him on a monthly basis because we just want to get on with our work, I'm sure as you also want to. And then I have to stop everything, and you're so busy, you have so many balls in the air, and then I get an email. Mr. So-and-so did not submit his identity document. And the fact is, I can fight as much as I want, but I have to comply with FICA. Okay, so what is the results or what is the consequences of not complying with FICA? So the failure to identify or verify your client, failure to keep records or to report suspicious transactions, you can be fined up to 100 million Rand or go to prison for 15 years. Then also failure to comply with your FICA internally, and I think this is more relevant to the smaller estate agencies, is 10 million Rand fine. Still lots, or 5 years imprisonment. Okay, so consumer protection law is, when I started doing some research, especially on the Food Stewards Clause, I saw that consumer protection is actually not a new phenomenon. It's very old. I came across references to texts where that's old consumer protection laws in India, in the marketplaces, since 3200 BC, before Christ. And they had quite gruesome punishments if you were not compliant with those laws. So, for example, if a merchant defrauded someone in a sale, he could have his hand chopped off, or whatever the case may be. So that's ironic, because I do believe consumer protection is it's law that's very difficult to enforce. Okay, so the Consumer Protection Act came into operation in March 2011, and it's a combination of years of, or several decades of legal development in the field of consumer law. So when does the Act apply? So it applies to every transaction occurring within the Republic, to the promotion of goods or services, to the promotion of any supply of goods or services, and also to the supply of goods or services. There are exemptions. The Act does not apply if the consumer is the state. I think if the state was a consumer, we would see a lot of tender fraud going away. Then the Act does not apply to a juristic person if his annual turnover or his assets is valued at more than 3 million rand. And so therefore, when you enter into any transaction with a person, it is advisable to ask, where do you fall on the scale in terms of turnover to determine whether you actually have to comply with consumer protection. Some definitions with regards to consumer protection. Supply, it means in relation to the sale of goods and services. The sale, rent, exchange, and hire in the ordinary course of business for consideration. That ordinary course of business is the key concept in the Consumer Protection Act. Then a supplier is a person who markets any goods or services, and suppliers in the property industry would then be property developers, estate agents, because you are also marketing and supplying a service, and of course us conveyancers, because we are supplying a service, we are supplying legal services. So the estate agent, acting in accordance with his mandate agreement, supplies a service and therefore falls under the definition of supplier. Also look at the definition of promote. It means to advertise, display, or offer to supply any goods or services in the ordinary course of business. Okay, so the CPA would then, in the context of estate agents, be applicable to your mandate agreement. And then depending on who the parties to your transaction are, to the agreement of sale. So let's just look at some of the provisions. This is not a comprehensive list. You will have a consumer protection session. Okay, so Section 11 and 12 places a restriction on direct marketing. I will discuss this again when we refer to the Protection of Personal Information Act, because there has been some changes. But note that there are certain prohibited periods where you cannot directly market to a person. So you cannot pick up the phone and say, hey, are you looking to sell your house during these times? So if you don't have the consent of that person, you may not market to him on Sundays, public holidays, or Saturdays, other than between 9 o'clock in the morning and 1 o'clock in the afternoon. And any other days, you may not market to that person after 8 o'clock in the evening until 8 o'clock the following morning. Okay, it's just something to bear in mind. Then, direct marketing. So Section 16 of the Consumer Protection Act provides that if a transaction is concluded as a result of direct marketing, then the consumer will have a cooling off period of 5 days within which he can cancel that agreement. Perhaps you can tell me how it will apply in your industry. I had to think of an instance or an example where someone could cancel as a result of direct marketing. I could not think of one in the context of property, but what I can tell you is that a friend of mine was duped into signing a gym contract in Pretoria when she was still a student. And when she got home, she realized that A, she did not really want this contract, and B, that they had signed her up to exercise at all the gyms in the country. It was the deluxe package, and she couldn't afford it as a student. And I didn't have consumer protection studies when I was at university, but she was very clued up because she's a bit younger. And so she went back to the gym and she said, I'm exercising my cooling off right and I'm canceling this contract. And so she got out of that contract very easily. Okay, fixed term agreements. Okay, it's an agreement which is binding for a specific period of time. This relates to your question on lease agreements. A fixed term agreement in the case of your mandate would be, a mandate agreement would be where you agree to market someone's house for a period of, say, 6 months. As soon as you have a fixed period, it falls under this provision, Section 14. And lease agreements will also be considered to be fixed term arrangements. Now, remember that Section 14 does not apply when both your parties are juristic persons. So the CPA prescribes a maximum period for which a fixed term agreement may be entered into. So the maximum period is 24 months. Okay. And then they also provide overriding provisions regarding the cancellation clauses in the fixed term contracts. So regardless of what your fixed term contracts say, the consumer has a right to cancel that contract provided he has given 20 business days notice. So if it states that the consumer has to give, if your agreement states that the consumer has to give 3 months notice before cancelling the agreement, well, you can now give a shorter period of time, 20 business days. A similar option is available to the supplier, but only in the case of a material breach. If your breach clause states that you have to give a longer notice period, that's no longer the case. You can also give a 20 business days notice for cancellation of that contract. Okay, when will Section 14 not apply? So we said when your landlord is a natural person and a tenant is a juristic person with an annual turnover in excess of 3 million, or where both the landlord and the tenant are juristic persons. Section 14 will apply if both your landlord and tenant are natural persons, but bearing in mind that the landlord will have to make supplies in the furtherance of his business. So if I am going to enter into a lease agreement and leasing properties is not my primary business, then I'm not going to have to comply with this. And then where the landlord is a juristic person and the tenant is a natural person, they have to comply. And where the landlord is a natural person and the tenant is a juristic person with the annual turnover or asset value of less than 3 million. Then you may have a cancellation penalty in your agreement, especially in the case of early cancellation. But that cancellation penalty also needs to be consumer compliant, meaning that you have to take a range of factors into account. Ultimately, the penalty needs to be reasonable reasonable if you compare it to the damages that the landlord had incurred, the duration of the lease agreement or the fixed term agreement, and the reasonable possibility of finding a replacement. And also having regard to industry practice. Okay, cooling off period. We said that if you enter into an agreement as a result of direct marketing, there's a cooling off period. You're also all aware of the cooling off period in terms of the Alienation of Land Act. That threshold has been increased to 500,000 from 250. Then the Consumer Protection Act has certain provisions regarding the disclosure of information and also the manner and style of the documents that you're drafting. These provisions are contained in Section 22 to 28, but in essence, they state that when you deal with a consumer, your document, your marketing material, whatever information you furnish to that consumer needs to be pitched to him at a level that he can understand. So when I have an ordinary agreement of sale, I'm not going to give them a 40-pager filled with legalese and so forth. It needs to be easily understandable. You have to consider the manner and style and form of the document, the vocabulary used, the context of the transaction, the comprehensiveness of the document. If I'm drafting an agreement for big property companies and we're buying and selling the buildings, then I'll deliver a 150-pager. We'll see how it goes. Then Section 23 deals with the disclosure of price of goods and services. It just requires the supplier to upfront disclose what the costs are going to be for the consumer. I think conveyancers and estate agents can tick the box there. When you enter in your agreement, the purchaser or the seller upfront knows that your services is going to cost, for example, 5% of the purchase price. I, as a conveyancer, have to provide a quote for the work first before the consumer can instruct me to proceed. And then Section 26 is a strange provision. It prescribes that the supplier of goods or services must provide a written record of each transaction to the consumer to whom any goods or services are supplied. I mean, I had to think back on how this is relevant in our industry. And the only example I could think of is when I purchased my flat from Pam Golding, the estate agent gave me a little starter pack. everything that I needed and any information that I needed now to continue living in my flat. That starter pack included my electrical compliance certificate, her details, a copy of the agreement of sale, the management rules and the conduct rules of the scheme in which I had bought, the financials of the scheme in which I had bought, and I think that is the type of thing that Section 26 envisages. Fair and responsible marketing, just in essence, when you market your services, you must do so in a manner that is fair and reasonable. It's very difficult to define. I think you'll have to use your own discretion. But ultimately, a person cannot be pressured into signing an agreement or entering into a transaction. Then your fair, just, and reasonable contract terms. I think this is the most important provision in the CPA. Also the most difficult to interpret, because what is fair depends on the circumstances. I've had some thoughts, I spent some time on this, and I think provision in the contract stating that the estate agent can claim commission, even if the transaction does not materialize, may be subject to scrutiny, if placed under scrutiny in terms of the CPA, may fall foul of the CPA, and may be considered to be an unfair or unjust contract term. A foot stewards clause also falls under that definition. But here I would like to pause and remind you that when it is an ordinary transaction, arm's length between two people buying or selling their house, you can have a foot stewards clause in your contract. However, as soon as the seller is making supplies in the furtherance of his business, then he falls under the CPA and he cannot have a foot stewards clause in his contract. I would also like to draw your attention to a recent case called Haverside versus Hadrix in the High Court Pietermaritzburg Division, where the court held that illegal structures, so structures that were built without building plans or structures that were built beyond the scope of approved building plans, is considered to be a latent defect. So if there's no building plans, that's something that you have to disclose. Otherwise, the seller may be held liable if the purchaser can prove that the seller withheld that information with the intention to defraud. So the conclusion is, with regard to the CPA, your state agent's mandate has to comply with the CPA, and then also the Act does not apply to sale agreements between persons who do not sell their property in the ordinary course of their business, such as individuals that occasionally sell their home. The developer, for example, will qualify as a supplier. The first step in determining whether you're acting for a seller is, the first step is to determine whether your seller who's selling his home is whether he's selling this as part of his business or not. And we advise that the agent will need to cover themselves by receiving the instructions from the seller and presenting to the purchaser as much information as possible. So do not be caught in a situation where the purchaser can come back and say, well, the agent told me so and so, because what can happen is if the seller is going to be held liable, the seller can also come back and hold you liable. It is important to remember that where a seller is ordered by a court to compensate the purchaser in terms of the CPA, the agent may also be at risk. And should the agent be responsible for certain communications made to the purchaser, then the agent can be held liable by the seller. Okay, protection of personal information. So this 2013 Act seeks to regulate the interaction between the constitutional right to privacy, as enshrined in Section 14 of the Constitution, by safeguarding certain personal information when processed by a responsible party, subject to justifiable limitations that are aimed at balancing the right to privacy against other rights, particularly the right of access to information, and also protecting important interests such as the free flow of information in South Africa. To whom does this Act apply? It applies to responsible parties. So, meaning a private body which alone or in conjunction with others records, processes personal information of data subjects by automated or non-automated means. And a private body can include a natural or a juristic person who carries on any business, trade, or profession. This is a very wide definition, and I think it's safe to say that as soon as you're dealing with personal information in the course of your business, then you will be a responsible party. I think it's also safe to say that we are all data subjects. So when I receive an SMS, and I receive so many, and I don't know where the people get my information from, Joshua Door, or this company providing a loan, and so forth, I'm the data subject in that scenario, and Joshua Door is the responsible party who is interfering with my rights under this Act. So POPI will apply then to estate agents who collect personal information, which will include emails, physical addresses, cell phone numbers, etc. And Section 5 states that a data subject has the right to have personal information processed in accordance with the conditions for the lawful processing thereof. So these rights of the data subject include the following: the right to be notified that personal information about him is being collected, the right to be notified that his information has been acquired or accessed by an unauthorized person, to object to his personal information being processed, to not have his personal information processed for purposes of direct marketing by means of unsolicited electronic communications, and then also a right to submit complaints to the regulator. Okay, so what does lawful processing mean? How can we use this information lawfully? So it means that information may only be processed if, given the purpose for which it is processed, it is adequate, relevant, and not excessive. And this is the most important: the data subject has consented to the processing of his information. So personal information must be collected from the data subject directly, except where the Act provides otherwise. So, for example, if this information has already been made public, then there's no obligation on you to get it from the data subject directly, if it is within the public realm. So ultimately, you need the consent to use that information, to collect that information, and so forth. Okay, so direct marketing. So we said under the Consumer Protection Act, there were certain provisions regarding direct marketing. Now the POPI has amended it. So it means direct marketing means to approach a data subject, either in person or by mail or electronic communication, for the direct or indirect purposes of promoting or offering to supply the ordinary course of business any goods or services. And so before POPI, the direct marketing was regulated by the Consumer Protection Act and also the National Credit Act and Electronic Communications and Transactions Act. And the position was that direct marketing could commence without the consumer's prior consent, provided that there was an opt-out. So before this act came to place, the situation was that if you had information on a person, you could use that information for purposes of direct marketing, even if you did not have his consent to use that information, provided that you have an opt-out clause. So you will see in your SMSs that you receive from all these loan sharks and so forth, at the end of the SMS it says, to opt out text this, or to opt out do that. That is the opt-out provision. So if you say, stop, I don't want marketing, I opt out, then you're not allowed to use that information anymore. But that was the position under the acts before POPI. So POPI has changed the legal position in that a responsible person has to obtain the consent of the data subject prior to direct marketing. Importantly, the responsible person may approach the data subject only once for his consent. Existing clients may be targeted for directing marketing, provided that a person has on a previous occasion given his consent. And then also all direct marketing measures must also have an opt-out clause. So to just go back, before the act, you can have all the information you required, but you had to have the opt-out clause. Now, after the act, each person on your database must have consented to his information being on your database. And in addition to that, you must also have an opt-out clause. So the implication is that, and I don't know to what extent it's relevant in your industry, but these loan shark companies and so forth buy information from somewhere. They get all these names, identity numbers, and so forth, and then they use that information for marketing purposes. This is absolutely prohibited in terms of the Act. If Joshua Door does not have my consent, they don't have a right to send me an email or an SMS, even if they have an opt-out clause. And sometimes I don't want an SMS back opt-out. Okay? So failure to comply, also, the Act also imposes administrative penalties of up to 10 million rand. So what does this mean for estate agents? Okay, so you cannot buy information. That's the first thing. Then obtain consent in order to use information. And also obtain consent before you do direct marketing. And there are strict security regulations. The Act also prescribes strict security regulations in respect of electronic data to prevent a situation where someone hacks into a computer and information is leaked. That is a bit technical, and I think too technical for this session, but if you want further information, you can email me. And you have an ethics session, so I'm not going to go on the Estate Agency Affairs Act and so forth. I just want to bring your attention to a case in the recent court decision where the court looked at the situation where you have a so-called spotter, a person who finds a client for you and then brings him to the estate agent. And the question was whether that person qualifies as an estate agent, whether he has to have his Fidelity Fund certificate, and then whether he should be compensated. And so the court held that as long as that person does not put himself out to be an estate agent, he does not have to have the certificate. In this instance, it's a contract between the estate agent and the so-called spotter. The spotter is not acting as an estate agent, and therefore he can actually receive some form of compensation. Contract doesn't have to be in writing, it can be a verbal agreement. Yes. But as long as he does not perform the actions of an estate agent, that is still considered to be a legal situation.